Well, thank you, everyone, for joining us. Welcome back to Media Apocalypse, our series about the threats facing journalism, news gathering, and the flow of information on matters of public concern in our democracy, and dedicated to exploring solutions, both legal and otherwise, for preserving the press function. The usual gang is back today, RonNell, Jack, and Sandy, and we are really thrilled to have Olivier Sylvain from Fordham Law School, professor of law, to talk to us about media and machine learning. But of course, actually, you can talk about whatever you want, but I'm going to ask you, I'd like to just ask you a preliminary question about the uses of machine learning and algorithmic decision-making in journalism and news gathering in particular. That is, I think we all know that Google uses algorithms, content moderation uses algorithms, but to what extent can you tell us where machine learning is being used in the actual production and curation of news stories?
Thank you very much, Scott, and thank you to RonNell, Jack, and Sandy for having me to participate in this conversation. Very much look forward to it. I hope I can keep up. I wish I knew all the ways in which journalism and media companies for the production of news is what I assume you're getting at.
Yes.
Rely on it. I don't, but what I'm reminded of immediately is this project that The Guardian launched, which you probably know about, this GPT-3 phenomenon, where The Guardian just kind of feeds a basic question or information to an automated decision-making system that cranks out an article. And the one I'm looking at right now is actually an essay where the assignment was to convince us that automated decision-making systems should not scare people. And the article's title, "A robot wrote this entire article, Are You Scared Yet Human?" Which is really great, and it's a really persuasive piece. So that's the first thing that I think about. What I also think about is, which I think is probably closer to what you mean than what I'm capable of answering. The other, what I also think about is data journalism, a phenomenon. I think that's it's colloquial, I think, but it does describe a species of journalism that's emerged that requires data scientists to do. So the most well-known, I think, is the markup right now, started by Julia Angwin, who was at Politico. And she, with a team of data journalists in 2016, broke really amazing stories about the ways in which Facebook was using the ad manager. And I've relied on that research. Civil rights lawyers have relied on it in connection with litigation against Facebook. And that has spawned, I think, a whole category of practice. So what does it mean? I mean, they're driven by basic journalistic imperative. And I think there probably are disagreements about what that should be. I don't think it to be, for example, to be fair and balanced. It's kind of a searching of powerful entities and the ways in which they impact our lives. And so they've used it to determine how they've used software, automated decision-making systems to determine how Amazon, for example, makes decisions about which products to privilege or other or not, right? They've done that in the context of Facebook, in the context of Ad Manager, and the use of proxies for race and other things forbidden under civil rights statutes. So that's what I think of. As for the practice of journalism, I don't, I can't say much more than that.
That was actually very helpful. Could we perhaps switch to the use of algorithms in content moderation? Because I know you have written more favorably about the uses of algorithms as opposed to humans curating content. And I was wondering if you could kind of walk us through like the pros and cons as you see it of using algorithms to moderate content on social media.
So I wrote this essay in response to Tim Wu, who is a far more open to the deployment of automated decision-making systems than I am. I actually tend to be more skeptical about the argument about their inevitability or even their desirability. But I mean, just to answer your question, in the context of social media, it is used. Automated decision-making systems are used for all kinds of things. The easiest one to make sense of, I think, are recommendations for friends, right? And this is based on information that social media collect on users. And it isn't just information that users openly and explicitly give. It's information that they just gather based on users' network, browsing behavior across the web, et cetera. And so that is a moderation decision to the extent the news feed or trending topics are conditioned by what the automated decision-making system thinks will continue to engage users. I mean, that's kind of a high-level account. I've actually been, the piece I've written is actually argued that Mark Zuckerberg testified to Congress a year and a half ago in 2018. He testified this year, but also a couple of years ago, in which, and that was where senators didn't show too well when they asked Mark Zuckerberg, whether or not what the business model for Facebook was. But just one of the things he answered in connection with concerns about disinformation online was that he was sure AI would come to the rescue in the long run. That as it becomes more sophisticated about the kinds of information that's misleading people, that it would be better at redressing than humans would be. I'm actually inclined to be pretty skeptical and that's a very strong argument. It's kind of a branded argument. I'm skeptical that is comprehensive of what social media do, because in fact they employ human moderators, tens of thousands of human moderators at the big companies, Facebook, Twitter in particular, across the world, to make first instance decisions about content. And then, and it might come in the first instance from a flagging decision-making system, but humans are actually deeply embedded in this. And there are people who've been writing about that. This wonderful book called Ghost Work by Mary Gray and Siddharth Suri, and Behind the Screen by Sarah Roberts, just kind of discovered the real political economy, the human labor involved in all this. So automated decision-making systems play an important role, but I think it is wrong for us to focus on them as the primary ways in which these companies make decisions about moderation. And one more point I'll make about this: these are what I've argued, that the moderation decisions are industrial design decisions. They're decisions that companies make about how to brand their product. And so Twitter wants to look one way, Facebook wants to look another. And the extent to which they want moderation is a function of their pecuniary commercial objectives, which is also, by the way, a human intervention, not an automated decision-making system.
I'm sorry, because I think I misunderstood your article, and maybe I expressed the point poorly, but I thought what you were saying, is this a better way of characterizing your position, which is that automated decision-making in content moderation is a tool that can be used provided that it is backed up by some kind of robust human decision-making? Would that be a better way of stating your view?
I think I do. So maybe I think that I'm not trying to be squirmy on this. I
know you're not, and I feel like I'm not being clear.
So I haven't been clear. So there is a prevailing argument, which is the Zuckerberg argument, and Tim Wu channels it, and that is there's an inevitability about automated decision-making systems, and that we should not be as worried about them. Right? It's this Guardian article argument, and I say that's not a complete account of what is actually going on. So it isn't that I think humans should be involved. I think they are involved. And what's more, we might want to be more strategic about where we locate humans in the decision-making chain. We aren't as mindful about it because there's a lot of this is a kind of branding exercise about the distinctive nature of technology and the way it's going to deliver us from our ills.
So one last quick question. Given the fact that human beings not only are in the loop, but I take it that you think that they must be in the loop because these are decisions that require an enormous amount of information and context. And at present, technology is not up to it. Maybe it'll never will be. Maybe there are other reasons that we want humans in the loop. But so do you think that content moderation at scale is possible? That is it one of those things where what we hope is that instead of having tens of thousands of human beings around the world, we want 50 to hundreds of thousands of human beings around the world engaging in content moderation? Is the problem that Facebook isn't employing enough of these people, or is it just that there's just no way to really do it at scale?
Okay, so that's a really good, hard question. And I think this is the argument for the past 20 years that intermediaries have deployed to argue for why they should be immune from liability, because there's so much content online, and it would chill speech if there aren't perfect mechanisms for moderating it. So I want to say that, but I also want to say, so the only way it works is if there are systems that are automating the traffic online, right? And because you can't, even 10,000 people, even 20,000 people is just not enough to do it right. How does one do it at scale? I think one needs, if one is committed to that, I think automated decision-making systems are necessary and maybe normatively desirable. But there's the prior, but there's a prior question of whether we're okay with taking that step, whether that kind of scale is ever a good idea. And there are people who've made a similar argument, although not gone that far. Siva Vaidyanathan is a serious critic of Facebook, and largely because it occupies so much of our public life, and its decision making is conditioned on its own kind of pecuniary objectives, but not attentive to the way in which people actually engage the service and application. And it's also a problem because of its size, right? So this is where scale matters. So I'm aware and attentive to that claim. I'm not totally convinced that it shouldn't or couldn't happen at scale.
Thank you so much. I'm gonna pass this over to RonNell for the next question. Thank you.
Thanks so much for joining us. I'm really interested in your work, and in particular, a theme of your work that's really interesting to me taps into the divides between how social media platforms depict themselves or conceive of their own missions versus how they sort of look to us as outside users. That is, how they operate in real functional terms in the lives of real citizens.
Yeah.
In your Columbia piece, you've argued sort of that we kind of have erred in treating social media applications as, in your language, pristine speech platforms for earnest democratic debate, rather than as presumably sort of commercial enterprises whose priority is to maximize data collection and user attention and engagement for advertisers. I'm hoping that you can sort of first speak a little to what specific harms you think come from that divide in characterization. And second, maybe speak to a second divide that we've considered in some of our conversations in this group, that social media companies have for a really long while emphasized that they don't see themselves as news companies, but rather as tech companies. All while the data sort of demonstrates to us that at least some people increasingly do get much or maybe all of their news through these companies in ways that are heavily influenced by those motivations that you described. So what does it matter that these gaps between characterization and real world behavior exist?
So I really appreciate the way you just framed that. I think you basically you answered my question. You answered the question in some ways in your account about the second point about the difference between how we receive what a news company is versus a tech company. But what are the consequences? I ask, what are the consequences of not seeing online intermediaries as commercial platforms in the way that I've argued, but as instead speech platforms? Well, I mean, it's a good question because I put a lot of weight on it, and one is there are constitutional consequences, right? First of all, but I think that's a kind of low-hanging fruit. For me, there are a whole set of regulatory tools available to consumer protection authorities, to public interest groups, to civil rights groups. If we remove the veneer, I think that's the word to use, but the veneer or the kind of, the framing of an intermediary as a speech platform, more as someone an entity that engages consumers and users to advance their own pecuniary and commercial objectives. And for me, this is actually does a lot of work because it suggests something about any safe harbors or immunities that protect them from civil rights litigation or consumer protection litigation. So that's for me an important takeaway. I very much like your question about the way in which companies see themselves as either tech companies or news companies. Early on, even Google, but also Facebook, really didn't like to be called a media company, nor did they like being called an advertising company, right? They were something different we had never seen before. And I don't think that was an argument that was addressed to what I just talked about, this kind of exposure to regulatory oversight. I think it was a branding exercise. And I really do think they believed that they were making connections possible in ways that were never available before. And it sounds messianic, but I mean, John Perry Barlow's well-known, often cited Declaration of Independence of Cyberspace meant to channel that sentiment, that there was something distinctive about what was going on. And it's a rhetoric that caught on and has done a lot of work. But I think the question you asked, I think that in that way dovetails with the first question, and I think it helps to answer it also.
Yeah, I think it's really interesting to think about how we conceive of new delivery mechanisms and how they map onto the old ones and don't map onto the old ones, and how our definitions and characterizations actually, in the way that you describe, can impact, even if it's not the design, even if it's not the goal, they do end up sort of shaping the ways that we have conversations and the ways that we design regulatory systems, which I think is really interesting. Thanks so much for that. I'm going to hand things over to Jack.
Okay.
Hello, Olivia. I want to go back to some of the issues. Actually, this is a synthesis of what Scott was talking about and RonNell was talking about. So here's a way into what the problem is. If you looked at the world before social media, you had journalistic organizations that had a professional element. They were professional journalists. They promoted the news. They saw that as their public duty. And they also had a business side. And the business side was basically interested in making money. And there was an interesting interplay between the professional side and the business side. And sometimes they were at odds, but often they weren't at odds at all. I mean, it's something that you and I have talked about. Now let's flash forward to the new world, in which what we have are not professional journalists operating social media, what we have are content moderators and people deciding how the algorithms work. And as you said, it's always people behind the algorithms, and deciding what the feed looks like and deciding whether or not there'll be recommendations and what kind of recommendations there'll be, and programming and designing the algorithms to do it, right? And then we also have the people who basically do what actually makes these companies money, which is act as advertising brokers. And that's really their business. They're the largest advertising brokers in the world, especially Facebook and Google. So I'm interested in how you think about what room there is for professionalism, and a professionalism that is devoted to the promotion of the public good,
Right.
promotion of the public interest, and as I like to say in my own work, the facilitation of discussion, of public discussion, which is of professional concern. How do we see that interaction between the professional and business side operating in social media companies?
Right. So I told Jack, I jumped on too early, and that's why I left. I told him that I saw his talk for a computer science group, ACM, at New York Law School last year on some of the same issues. And I thought, there he goes again, writing about stuff that I want to write about, doing it better than I could do it. He isn't the only one. And I just to mention, there are a couple other people who are talking about professionalization in this setting, but not about media, which is what you're getting at. And and the question. So I have presented a version of this paper. I just haven't written it. And the driving question is, how do we engender a sense of social obligation for social media? And the mechanisms we generally have for thinking through that, I think, is professionalization or law. And law is, for me, I have to admit, I'm probably likelier to be open to public law interventions than most. That's what I think of. And the paper tries to, and I've written about where law can intervene, but the paper tries to the idea of the paper tries to sort out how we engender that sense of obligation. I think there are salutary benefits to lifting the immunity under Section 230, but I know Sandy will get to your question about that in a second. But how do we align? So you set it up exactly right, Jack. So how do we align this kind of public-minded interest in getting information and retaining the integrity of the information for the purposes of the operation of democracy, while in the context of a business model that is driven by the collection of user data?
Yeah, so I'm going to give you a way into this question, because I'm going to have you talk about law. So here's an idea that I've been pushing around. You're going to see it meshes beautifully with what you're thinking about. Suppose we treat Section 230 as a regulatory bargain. That is, it's a subsidy. It's a subsidy we give to companies in return for doing stuff for us, just as we gave broadcasters free spectrum in exchange for taking on public interest obligations. So you are now the head of you're Congress, right? You're the lawmaking branch, and I tell you that I'm going to use the Section 230 immunity as leverage. If you do this for us, you'll get this incredibly valuable subsidy, which preserves you from all sorts of lawsuits and other regulatory hassles. So what do you ask them in return? What public interest obligations should we ask of these social media companies in return for the enormously valuable regulatory immunity we're giving them?
Okay, that's a really excellent question that no one has asked me before, but it really is a question that I should have an answer to, because it's about law, but it really isn't. And so because it pushes me to think about what does it look like when a professional institution that traffics in information and content does it right. I think that's what you're
exactly. I mean, and they don't have to be perfect. They just have to move slightly toward what you were talking about before, that they take seriously their obligations to the public.
So I think my reaction is my answer is a bit reactive, and maybe it will not be satisfactory.
We're going to help you write your paper. That's the whole thing.
But it's helpful. So I think that there's there's enough for us to be worried about in the ways in which news organizations and media do their business that I'm far readier to say, don't do this and don't do that than to advise how they should do the business. And this is a story we can talk about this in the context of radio and broadcasting.
Right.
We can talk about this in the context of newspapers. And I think that we are worried about drawing lines for media companies for constitutional reasons, maybe other ones. But I'm far more comfortable with drawing them to the extent that we are sure that they don't discriminate against, in the information they distribute, they don't discriminate in the kinds of information they give to people. I guess, so maybe this is one of the things I would ask them to do. You've helped me a lot with this question.
This is basically, we're working out this
right.
paper.
Do not target content disparately, or that is I have worries about targeted advertising generally, but in the fracturing of the public square, which I think is an old way of thinking about this, but still feels very real and current, is powered by intermediaries' ability to communicate different ideas to different people, or different concepts of the same idea to different people in ways that are misleading and misdirecting.
Right.
And so the reason I say that there are salutary benefits to amending Section 230 is that it would redirect companies in ways they aren't now to attending to public law norms, and public law priorities like consumer fraud, but maybe to the public interest in like ensuring that different people don't get different kinds of news.
So one thing you could ask is, you have to agree that your targeting algorithms are designed in a certain way. So that would be, in exchange for the subsidy, you have to guarantee us that your algorithms that target and basically decide the news feeds for folks, and the advertising, not just the news feeds, are designed in certain ways. But that will lead me to the second thing we might want to ask. So if that's what you want to do, then I want access to the algorithms. In other words, I want some trusted third party to basically take a look at what's going on, so that it's like Reagan, trust but verify. So that you need a kind of trust but verify model for the design and implementation of the algorithms in order to make sure that the algorithms are in fact doing the public interest stuff you want them to do. Right.
So I haven't focused a lot on it, but I'm inclined to agree very much with people who've been talking about a statute that I know Jack knows a lot about, and I think you all have probably heard about, the Computer Fraud and Abuse Act, as a mechanism for ensuring, for allowing a public interest deployment of, as in data journalism, mechanisms to see how algorithms are actually working without violating the proprietary interests of.
Well, yeah, and as you know, CFAA kind of gets in the way.
Well, that's the, I mean, should it? And maybe it shouldn't. That's what I'm saying. So maybe we should have a mechanism that allows third parties, journalists is generally who I think of, like Julia Angren or ProPublica or whatever, to access the workings of the algorithm without violating, trespass to chattel or some CFAA conception of proprietary protection. So that gets to that, but I think they have to be pushed, right? I think that a third party is necessary. I don't think it has to be, a government agency. I do think journalism plays that role. Julia Angren, actually, who is a friend of mine, this is like the fourth time I mentioned her, but I've been thinking a lot about her because she recently posted something on Twitter about how data journalists are actually the content moderators for these companies.
Yes.
Which is, it's exactly right. No one has put it that simply to me, and I think it's exactly right. The only reason that Twitter and other companies and Reddit have changed their policies is because they've been held to account by journalists or public interest organizations.
Good. And actually, this is yet another model we can take from the 20th century. So one thing that we understood the press is doing, one of its functions was as a check on power and bringing power to account and holding it accountable. We have a new form of governance. This form of governance is data governance by these large entities. So journalists are actually performing some of the same duties, only now the people they're holding an account are these companies, the companies that are governing us with data. One other thing.
Brand new variety of the fourth estate.
Absolutely, absolutely. The fourth estate 2.0. I was just thinking one other thing related to Scott's question would be something like this. Do you want, in return for this incredibly valuable subsidy, which is essentially being given, do you want them to make any changes in their labor policies with respect to moderators? These armies of moderators and, in these all over the world?
Yeah, I think for me, that's an easy answer. Absolutely. And the nice thing about that is that it would also help. I mean, I don't know how you force them to do it other than exposing them to regulation, but it would force them to internalize the costs of having this content, really nasty content, going out in the world. And I think it would have a chilling effect, by the way, right? If it costs.
In what sense?
Well, people have talked about post-traumatic stress this quarter as a result of just doing content moderation for a year or two. Yeah. And a lot of these companies are just really lousy at helping employees, contractors, get better. What if they internalize that cost? They might decide that there's just some content we will never allow on, right?
Right.
Which would have a chilling effect. But I'm not worried about that chilling effect. I actually think that's how content gets moderated in a way that might resemble the sorts of things we, would want to see them attend to. So, I think it's not until the Christchurch massacre that Facebook really started thinking about automated systems that would detect live shooter point of view attacks, mass murder attacks.
Right.
If there's anyone capable of developing that mechanism, it's Facebook. But it took that to happen. There had to be a human at one end to make that decision,
right.
And it mustn't have been a pleasant experience, right? So maybe one way to have them internalize the costs of the stuff they allow is by imposing labor, right? That they attend to the workers that are actually doing this work, and they don't because they're contractors. But
right. No, but the way you do it is just like you do with OSHA. That is, you have the OSHA inspector comes in every now and then and checks the place out and has to interview everyone. So whatever this new agency we're creating for dealing with it, as part of the bargain, will basically have people, they'll send people out. And it shouldn't matter whether they're contractors. I mean, it shouldn't matter at all what the status is.
Well, I mean, this takes us outside of the area of media, but as you know, it does matter because under law, non-employees, contractors, freelancers are not entitled to as much protection, and there are a variety of intermediaries that know that well. Uber is probably among the most well-known and notorious. And
well,
this, by the way,
the way you design the statute is, you say you're responsible for the health of your contractors as well as the mental health of your direct employees.
Right, and I would address that to more than just media companies. That's why I say it's not just. Or social media. It's not just social media, right? It's a general labor policy that this is my politics are revealing themselves, but this is a failure of labor policy generally.
Actually, I mean, this is a great point, because I think that people who work in this field of media policy don't realize how it bumps up against labor policy. I mean, it bumps up against labor policy, consumer protection, and a whole bunch of other things, and that's just because of the nature of the world we've entered.
And I think this is the other answer. This is the better way of answering your question, RonNell. So I mean, I said there are a variety of, regulatory tools that might be available to us if we saw the companies for what they really are, what I say they really are. And if they are employers, right? If they're in the business of entering contracts with workers, then we might be readier to see them as obliged under those provisions. We don't now. I think the prevailing view is that they operate in the cloud or simple speech platforms.
Thank you very much. Sandy.
So many directions one could go with all of this, Olivier. Thank you. And it makes me smile to hear Jack talk about OSHA stepping in, since so many current employees in current existing corporations across America, I suspect, are wondering where OSHA is in terms of their employment venues, even for those who are independent contractors or actually employees. I tend to look at the flip side of Section 230 in some sense from what Jack was asking you. It's interesting to think about what Congress might do as a bargain if the companies got to keep Section 230. But I know that you've been critical of the way Section 230 has been read by the courts to date. And I thought it was worth asking you to talk about that, and certainly invite you to tell us how you might amend Section 230 if you were given that magic wand.
Right. So the piece I wrote in 2018, I wrote something smaller as an anniversary of the foundational case after this Section 230 is passed. The Zarin case was decided in 1997. There was a 20-year anniversary thing that I wrote with a bunch of people, some critics and some supporters. But the piece that I've written that took this up was addressed to reform, and addressed particularly to the way the courts had been making sense of the doctrine, have been making sense of the statute. And I think they get it wrong, is what I argue. But we're not there now in 2020. People today are talking about legislative reform, and there is a bipartisan interest in it. It's odd, like there's bipartisan interest in anything. It's this, but it's a bizarre alignment, and it's one that's made me very uncomfortable because I've been a longstanding critic of the doctrine, but the White House's intervention and conservatives' intervention on this, frankly, is in my opinion really bad. We can talk about that if you want, but I'll let me make the affirmative case that I'm so. I alluded to it a second ago. It's a safe harbor. It's actually conceived of as a safe harbor in the 1990s. Was meant to promote moderation, to lift the burden of having to worry about getting moderation wrong. And in light of how much content, and I guess it's Scott's question about scale, in light of how much content was out there, we would expect them to make mistakes from time to time, and we shouldn't impose some kind of secondary liability for the mistakes they make. Because if we did, that would have a chilling effect on content. I get that. It's persuasive in many ways. The courts have said the only reason they would be liable is if they materially contribute to the content under the statute. But they've read that so broadly to encompass so much. And today, when we know that the intermediaries moderate content, but more than that, deliver content pursuant to their own commercial pecuniary objectives, it isn't quite right to say that they're not materially contributing, as far as I can see it. But courts don't even get to the question of how engaged any individual defendant intermediary is, because it's such a robust protection. It's invoked at the motion to dismiss. So one reform would be to, for example, and I'm on board on this. I've been collaborating collaborating is strong. Senator Schatz's office has been talking to me. He's about this, and one way that this could work is by imposing the obligation to remove unlawful content. Now that may not seem like controversial intervention, but in this area it is, because there is no burden to do that. And unlawful content could be represented in a court order, or it could be the sort of stuff that we all know to be unlawful, as in Backpage, with Backpage trafficked in child pornography, knowingly, but because they were an intermediary and not the people that were posting the content, they could claim an immunity on Section 230. The reform would impose a burden on them to not allow that stuff up. Listen, to me, it's intuitive that this be the case, but it is actually not the state of the law. So that's an easy reform. And that's one way that I think we could hold intermediaries more responsible for the content that they serve.
Olivier, let me just stop you there, but I want you to keep going. But when you talk about removing unlawful content, that which has already been adjudicated, or which is merely alleged?
So the reform would be conditioned on a notice that comes from a court order, right? So it's been adjudged. But one could read this more. You can be more adventurous in thinking about categories of content that are unlawful, like child pornography. But just to be clear, many intermediaries don't keep that stuff up. but they don't do that because they're going to be subject to lawsuit. They do that because there's a market for moderation. They know that their consumers will be annoyed and that they'll go somewhere else. So I mean, I do appreciate that there is a kind of, the market for moderation might lead us to the right place. It just hasn't. It just hasn't. And one way, and the only way it has is when these companies have been held to their feet to the fire by journalists and civil rights groups. And I've written a lot about the ad manager that Facebook's written about, that Facebook operates. The ad manager is, and you probably read about this, but if you've read the Recovering Text Humanity piece, because I talk a little bit about it there. The ad manager allowed advertisers to reach people on the basis of, on dimensions that are suspect categories. And they generated, and Facebook generated those categories. You know, it's not clear how they did it, but mostly through automated decision-making systems that found that these categories were salient. And they would allow them in the context of housing, education, right, and finance. We never found out how implicated Facebook would be in any given circumstance because of the protection. And they were ready to invoke the defense in lawsuits that were brought by civil rights groups. I know because I was a consultant on the complaint brought by the National Fair Housing Alliance. So they decided to settle the case, maybe in recognition. I like to believe it's in recognition of how exposed they were. But these companies are going to keep doing it unless they've been held to account. So that's, you know, giving them notice that something is unlawful, I think, would be a good start. And open up discovery, you know, and open up a more robust kind of regulatory oversight of companies than we've seen.
So you're actually, to some degree, on the same page as where Jack was going, which is the transparency of the algorithm.
Yeah. Yeah, go ahead, sorry.
No, you finish.
Well, the litigation is a traditional mechanism for that, right? Discovery. If the allegations are colorable and survive, you know, based on the substantive statute that is alleged being violated, discovery is supposed to reveal that stuff, right? And if you can't prove your case, you fail. We never get there because of the robust protection under 230.
So your primary change to Section 230 would be this requirement to take down that which has been determined to be unlawful. Any other refinements you want to make on 230?
Well, I'm more worried about a scienter or a mens rea requirement, which we have in the DMC, in the IP setting. When an intermediary knows that they're trafficking and they're in unauthorized copyrighted work, there's a notice and takedown regime under the Digital Millennium Copyright Act. And it's basically based on kind of knowledge, depending on the nature of the knowledge, but once they have knowledge that the stuff is on their platform, they're obliged to take it down. So some people have argued that we could do that in this setting. And notice of unlawful content comes close to that. But this notice would come from an aggrieved party, right? Not just, you know, not an order from a court. And there are people who are worried about the heckler's veto in this setting, that anybody can, you know, a conservative person who thinks his viewpoints are being discriminated against online can submit a notice that this is happening and it's unlawful or illicit or something, and impose that burden because of the notice and takedown regime on an intermediary. So I do worry a little bit about that in this setting, but I think I'm eager to see a tinkering that's addressed to exposing or allowing lawsuits to proceed if there's notice of an adjudged unlawful content. I think also distinctions between big companies and small ones is important. Only a handful of companies are really capable of handling notice of bad content, and there are bills on the floor that on the Hill that do that. Those are the ones that I think I'm most enthusiastic about. Another reform act, one last one. I'm sorry if this is too inside law on this, but one other is to empower federal agencies the Federal Trade Commission to bring lawsuits. So no private cause of action, no private attorney general, but government civil enforcement of consumer fraud or civil rights statutes. That's something that I actually think is a really good idea as well.
Even today, I mean, to some degree, isn't that consumer protection side of it somewhat along the lines of what the Department of Justice, in much more detail and with a lot more layers, has just proposed?
Yes, but I don't think those cases would succeed. I mean, I think there are serious problems with those arguments that address the speech interests of the intermediaries, right? I wanted to distinguish that out at the outset. The argument that they're making is that YouTube or Facebook or Twitter is discriminating against conservative views, and there are too many cases now that make plain that intermediaries have a First Amendment interest in are in a position to be able to make those decisions. I think you're right that the Department of Justice or the FTC or whomever could probably bring lawsuits. I'm just not sure they would be very successful.
One small thing that I may have misunderstood when you were talking to Jack, it was a throwaway line, perhaps, that you said there was enough to be worried about in the way media does its business, and it caught my attention, and I wondered what you were thinking about.
I wish I didn't do throwaway lines. I wish I was more.
Or better, that people weren't taking notes while you were doing it.
I wish I was more thoughtful about the things I said. So I was thinking about discrimination in hiring and the kinds of content that newspapers and media have focused on. Regulatory intervention has been necessary in the context of broadcasting, for example, to ensure diversity in content. That was a battle of the 80s and the 90s. I think that we still worry about newspapers that have I should say that we don't really have newspapers in the same way, but historically in the 20th century, local newspapers occupy something like monopolies in their local areas, kind of inherited wealth. So I don't think they're a beacon of, I think there are a whole set of problems associated. There have been historical problems with media companies generally, and that's all I was just referring to. They're just, there are enough problems in media generally that I would want to be alert to them rather than expect that if a social media company acts like a media company, that they would, ipso facto be a legitimate or good public actor. Does that make sense? Yeah.
Utilized the time that was allotted to me, and we probably should be saying thank you. And we really appreciate your having participated in these conversations. I must say I've found what you had to say here and the articles of yours that I've now read to be incredibly interesting and worthwhile. And you have a whole slew of thoughts and ideas about things that can be done to enhance the media landscape that we haven't even touched on. And so you may hear from us again.
Well, I should say thank you so much. So yeah, thank you very much. I appreciate it.
Thank you for your time. And thank you everyone for watching the next episode of Media Apocalypse. We look forward to seeing you again.